All right, folks, welcome back. Today we are going to look at the struggle to achieve equal protection under the law as promised by the 14th Amendment. We're going to do this through the lens of a particular social movement, the civil rights movement. The civil rights movement is the long struggle to achieve equal protection on the basis of race, whereas the equal rights movement is a movement to achieve equal protection on the basis of gender. Today, my goal is to give a brief history of the struggle for equal protection on the basis of race. But because of intersectionality, the interdependent nature of discrimination, this history should inform you of the struggle of other groups have waged to achieve equal protection. They kind of all go together. They all borrow techniques and strategies from each other. Okay. All right. So this first image is a reminder that a social movement is a movement of the people, not government. Okay, so one strategy of social movements is to gain allies in government, but its power will always come from the people. If you really want to understand the civil rights movement, the one that we're talking about today, okay, if you really want to kind of understand the racist attitudes, beliefs, and values that had to be challenged and exposed, the everyday violence that was perpetuated on our Black brothers and sisters, you should watch the documentary series Eyes on the Prize. The first episode, Awakening, starts with the murder of the 14-year-old Emmett Till. Okay, and then the whole first half of the series that extends from 1955 with the murder of Emmett Till up until the passage of the Voting Rights Act in 1965 really documents with utter clarity, okay, the struggle against de jure discrimination. There is another second half to the documentary as well that extends into the 80s that looks at the struggle against de facto discrimination. So that is much better than anything that I can tell you in like a 30-minute lecture. Those documentaries are very powerful, and you hear directly from the people that were involved in the struggle. All right, my brief history will not do the topic justice. All right, but let's begin. So here you kind of see the timeline. This are the events we're going to cover. We'll talk about more things in here, but if you know these elements of the timeline, you're in good shape. Now, Dred Scott versus Sanford, we actually talked about in the previous screencast. So Dred Scott was the big low point in Supreme Court history. Okay, that the decision of the court there was that whether you were a slave or a free person, if you were Black living in the United States, you could not be considered a citizen. Okay, that was where we start. That's our starting point. Then we move on to the Civil War, and we have the 13th Amendment. Okay, so the 13th Amendment said neither slavery nor involuntary servitude shall exist in the United States. However, immediately upon the passage of the 13th Amendment, you saw a lot of communities and states in the South start to pass black codes. And black codes were an attempt to legislate an unequal status on the basis of race. So they tried to preserve the social and economic dominance of the pre-Civil War social order. And they were laws that basically differentiated on the basis of race. That's why we call them black codes. Okay. So Congress, in response to the Black Codes, Congress responded with a period of federal control of the South that we call Reconstruction. And that lasted from 1865 to 1876. During that period of time, they were able to pass two additional amendments that we call the Reconstruction Amendments or the Civil War Amendments, the 14th and 15th. And one of the goals of the 14th Amendment was to make black codes themselves unconstitutional and to extend equal protection and civil rights to Southern blacks, to expand the notion of who the people are in the phrase "we the people." Okay. However, even with the passage of the 14th Amendment, now that we know it, okay, that the 14th Amendment, defined citizenship. It allowed for due process against the states and required equal protection, right? That when you could no longer discriminate on the basis of race, Okay? All of a sudden, there was the Jim Crow era. So Jim Crow was a derogatory characterization of African Americans based on a dance performed by a white actor in blackface. And that dance, that character that this guy created, came to be symbolic of the entire era of this. Is like post 14th Amendment. So when we talk about Jim Crow laws, what we're talking about is laws that were designed to circumvent the protections of the 13th, 14th, and 15th Amendment and try to, again, maintain that pre-Civil War social order, but do so on bases other than race. We studied some of these things earlier in the year. So we looked at poll taxes and literacy tests, okay, as qualifications to vote. We know that they effectively disenfranchised Black Americans, okay, but they didn't do so because they were Black. They did so because you couldn't pay the tax to vote or you couldn't pass the literacy test. Having taken the literacy test, you know that it was completely unfair, and the whole purpose of the test was to tell someone, no, you couldn't vote. Okay? All right, now to make sure that you weren't actually catching poor white people in these attempts to disenfranchise large groups of people, you had grandfather clauses. So if your grandfather had been allowed to vote, then you weren't subject to these same rules. You were grandfathered in. You didn't have to take the literacy test. All right, so that's just some aspects of the Jim Crow era and how they got around the 14th Amendment. So that brings us to Plessy versus Ferguson, which is the other low point in Supreme Court history. So you might be familiar with this case, Plessy versus Ferguson, 1896. Now, Homer Plessy, well, there was a law in Louisiana. Okay, so the facts of the case. A Louisiana law that required separate railroad cars for blacks and whites. And Homer Plessy was a black man that challenged the law by sitting in the whites only car. And then he was arrested when he refused to move to the blacks only car. So the case went all the way to the Supreme Court. And the question before the court was, did Louisiana's Separate Car Act violate the Equal Protection Clause of the 14th Amendment? And this is where we get an infamous decision, right? A low point in constitutional history, because the court said no, that segregation itself was constitution. Okay, it did not constitute unlawful discrimination. As long as the two railroad cars were relatively equal in their facilities, it was fine. Separate but equal became the law of the land. And you saw that applied throughout the South. Okay, whether it was education, whether it was public accommodations, whether it was railroad cars, separate but equal, separate facilities. Okay. Ooh. All right. Now, before we can talk about Brown, a little background on the rise of the NAACP, so the National Association for the Advancement of Colored People. Founded in 1910, the NAACP sought to dismantle de jure discrimination of the Jim Crow era. The NAACP purposely targeted segregation in education. They did so because segregation in education was disastrous because it limited the potential of a whole group of people, a whole segment of society. So the NAACP strategy, they first targeted law schools, and they did so very purposely. It was strategically because they knew if they were going to use the courts as their venue, and they understood that the justices that they would have to argue before understood how law schools operated and how they benefited them and how it got them to the positions that they were in. So we get to this court case in 1950. It kind of sets the stage here. It's called Sweat versus Painter. Hang on one second. Okay, so a black law school candidate, Herman Sweat, okay, applied to a white Texas law school, and he was denied admission, but Texas offered him a separate facility. Now, the separate facility that they were going to offer for Herman Sweat was 3 basement rooms and a part-time teacher. Okay, so the NAACP took on Herman Sweat's case, and they brought it all the way to the Supreme Court, where they argued that this was unequal. These two facilities were inherently unequal. Okay. Now, here's kind of the genius piece, though, where they set the stage for Brown, because they said that additionally, let's just say, for argument's sake, that the 3 basement rooms were equal to an entire university system, that there was comparable facilities. They still argued that Sweat's education would be unequal because he wouldn't receive the same benefits from the reputation of the more established institution. And he also wouldn't receive, okay, the benefit from building relationships with other students that you could then maximize to kind of achieve your potential and get good jobs, networking, as we say. Now, this is where we actually see the genius of the whole strategy, because each member of the court understood the intangible benefits of having attended an elite education institution. Okay, so they ruled in favor of Sweat, which really set the stage for Brown versus Board of Education. But before we could talk about Brown versus Board of Education, you also have to understand that Korematsu versus the United States played a huge role here. Okay, so that was the court case that basically said that racial discrimination by government, so rules government makes that distinguishes on the basis of race are going to be suspect. We're going to assume that they are unconstitutional, and they would have to pass the strict scrutiny test in order to be constitutional. And even though in Korematsu, the decision was used to limit the rights of Japanese Americans, in this case, in this venue, it gave African Americans another legal argument to attack de jure discrimination and the separate but equal doctrine. All right, so Brown versus Board of Education. Now, this is an AP required case. It was the case that they used last year on the test in the SCOTUS comparison. Okay, so you could draw in information about this case in any argument essay. For that second piece of evidence, you can use anything. Okay. All right. The facts behind Brown versus Board of Education was actually a consolidated case. So arising from four separate incidents where a plaintiff was denied admittance to the school of their choice based on their race because of the separate but equal precedent. So the question before the court was, does segregation in public school based solely on race violate the Equal Protection Clause of the 14th Amendment? And I'm sure you're familiar with the decision, but just connected to Plessy versus Ferguson. They overturned that precedent that was established in Plessy. And they said, yes, separate but equal facilities are inherently unequal. Okay. And part of their argument was to point to the intangible benefits, that you're not receiving equally the same benefits because you have to attend separate facilities. They also pointed to the sense of inferiority instilled in African American youth for having to attend separate facilities. All right, so that kind of the new law of the land is that separate but equal is inherently unequal. Okay. So now we get to, I got to flip the page here, sorry. Okay, so while the NAACP was seeking to achieve equal protection through the courts, the civil rights movement, led by leaders like Dr. Martin Luther King Jr. and Malcolm X, were using the power of the people to highlight the injustices of segregation. So in the same year as the Brown decision, there was the Montgomery bus boycott. And whether it was a sit-in, it was a march, or a boycott, these tactics were designed to bring public pressure on elected officials and to gain them as allies to dismantle the system of segregation. And when at some point, so in the 1960s, you start to see enough allies. And the big one is they gain an ally in the White House and Lyndon Baines Johnson. Okay. So once you have those allies in place, you start to see success beyond the courts. So the Civil Rights Act is a law passed by Congress that was a big success in dismantling de jure discrimination. So what did the Civil Rights Act of 1964 do? It did three things. Okay, so first involved segregation. So segregation on the basis of race, but not just race, religion or national origin was banned in all places of public accommodation, including courthouses, parks, theaters, hotels. Okay, couldn't do that anymore across the country. Secondly, employment. Okay, so the act also barred race, religious, national order, and gender discrimination in employment. Employers could not use that as a factor in determining who they wanted to hire anymore. And finally, in funding. So The Civil Rights Act forbade the use of any federal funds for any discriminatory purpose, whether it was at the state level or local program level. And you start thinking about the state's reliance on categorical grants and block grants. This was huge. Okay, you basically could not use that money anymore for a discriminatory practice. All right, that's the Civil Rights Act of 1965. Okay, or 64. Sorry. The next one, Voting Rights Act of 1965. Now, if you were with me first semester, we watched the first episode, or sorry, it wasn't the first episode, but we watched the episode of Eyes on the Prize that dealt with the events leading up to the Voting Rights Act of 1965. And that episode gave a very stark portrayal of how poll taxes, literacy tests, registration requirements, and intimidation by public officials, okay, were used to disenfranchise African Americans. So, the Voting Rights Act was designed to kind of prevent all of those things from being used and to make sure that the right to vote, your citizenship's right, were extended to African Americans. So the first thing, the provisions of the Voting Rights Act. The general provision applied across the entire country. And it said literacy tests, you can't do them anymore. They're against the law. And they also prohibited intimidations and threats designed to prevent people from registering to vote or engaging in the act to vote. There was a second special provision that only applied to certain states and local governments. So in this case, if your local community or your state, if you had, and we're an area where 50% of the non-white population, so less than 50%, had registered to vote or turned out to vote, then you came under federal oversight. And anytime you wanted to change the rules around voting, registration or otherwise, is you had to get the federal government's okay. We saw that in Shaw versus Reno as well, okay, that provision was still in place. Okay. However, more recently, 2013, there was the Supreme Court case Shelby County versus Holder, and the court in that case ruled the special provision formula unconstitutional. They said that we had gotten to the point where the conditions that made the special provision necessary no longer existed. So at this point in time, it was unconstitutional. So since the Shelby County, you can look at those communities that had been under federal oversight, and they've been free to change their voting laws however they want to. And you can go in and you can look at, all right, so what was the voter turnout pre-Shelby County and post-Shelby County, and who's turning out to vote, and you can draw your own conclusions about the impact of that court case. All right, so in the struggle for civil rights, there are some other Supreme Court cases that aren't required by the AP College Board for you to know, but you should know them. And one significant case is Loving v. Virginia, 1967. So in this court case, you had Mildred Jeter and Richard Loving, and they were interracial couple. They were married in D.C. They returned to Virginia, but were charged with violating Virginia's miscegenation law. The Lovings were found guilty and sentenced to 1 year in jail. And the judge said, hey, you don't have to actually spend that year in jail. Just leave Virginia and don't come back for 25 years. Because Virginia had a law that prevented interracial marriage. Okay? So they sue, and it goes before the Supreme Court. And the question then is, did Virginia's anti-miscegenation law, did it violate the Equal Protection Clause of the 14th Amendment? Now, the conclusion of this case is significant, doubly significant. It's significant because they said yes, okay, that any kind of anti-miscegenation law is unconstitutional. But the argument they gave has been borrowed and adopted by other social movements to expand rights for other groups of people. So the court applied the strict scrutiny test, and they said that there was no compelling interest for this type of discrimination on the basis of race. They also said that the right to marry the person of your choice is a fundamental liberty that cannot be limited by the state. Now, that might sound more familiar to you because that was the same argument that was made in Obergefell v. Hodges, which is the court case that made same-sex marriage legal across the country as well. All right, moving on. So we get to our last court case that we're going to talk about today. It's the Regents of University of California versus Bakke, and the case was in 1978. So this is in that completely different era here. This is when we're talking about de facto discrimination. Okay, and one of the tools to combat de facto discrimination was affirmative action. So affirmative action, just to give you a clear definition, it's when government creates opportunities for historically underrepresented groups as a remedy for past discrimination. Now, that's the definition. However, the affirmative action remedies themselves can be placed on a spectrum from substantive remedies all the way down to procedural remedies. So on the substantive end, you might have racial quotas where you have to reserve a certain number of spots in your new freshman class to people of like 10 spots for this racial group. Whereas in the middle, you might have more like you use race as a factor in admissions. It's not the sole factor, but it's one of many factors. So if you have people that are all equally the same, maybe it's the race factor that actually puts someone over the top and gets them admitted into the university. And then down at the very procedural end, you're going to just have outreach opportunities where you go and you publicize in certain communities that might be more of color so that you get more applicants to the university. But then once they apply, race is no longer used as a factor. Okay, so the thing that you have to kind of understand about that is the more substantive the remedy, the more likely it opens itself up to claims of reverse discrimination. Okay, the thing about Regents that you have to know, the reason we study is that it's the case that gives us the guidelines for where the constitutional remedies lie. Okay, so where on the spectrum do we find the constitutional remedies? So here are the facts of this particular case. You had Alan Bakke. He was a 35-year-old white man. He had applied twice to the medical school at the University of California, and he had been rejected both times. In the school, all those times he applied, the school had an affirmative action policy with a strict racial quota, where they had 100 incoming spots, and they reserved 16 for, I believe it was minority students, is what they called them back then. Okay. And when you looked at Bakke's credentials, his actual qualifications, his qualifications were often better and exceeded some of the minority applicants that had been admitted. So he argued that his denial was really only because he was white. Okay, so he took it all the way to the Supreme Court. And the question before the court was, did University of California, did their strict racial quota policy, did it violate the 14th Amendment's Equal Protection Clause and the Civil Rights Act of 1964? Okay. Now, this is one of those cases where we get a conclusion. We're like, huh? Because really it was 4-4, and there was one guy that voted in the middle, and the guy in the middle voted on both sides of the case. So it's almost a 5-5 case. So no and yes. So there was no single majority in this case. You had 4 justices that contended any racial quota system was unconstitutional, okay, and violated the Civil Rights Act. Then you had the guy in the middle, Justice Powell, right? And he said, yeah, you know what? He agreed and that the racial quota policy was unconstitutional. However, he extended it. He said, however, in his opinion, he argued that the racial quota system was a violation of the Equal Protection Clause. Then you had 4 remaining justices that said using race as a criterion in admissions is perfectly fine. And then Powell also agreed with them, but he kind of adapted the argument. He said, yeah, it's fine if it's not the only factor. You can use race as a factor because diversity in higher education in your student body is a compelling state interest. The more diverse your student body, the more the theory is people will learn better. They'll be exposed to different ideas. They will learn from people that are different from themselves. So diversity in your student body, a compelling state interest. And you can use race as a factor to achieve diversity in your student body as long as it's not the sole factor. So that's where we are with Regents versus BAKKE. So they said affirmative action itself is okay if it's kind of that middle of the road, a little more procedural than it is substantive. Okay. So to review for today, the civil rights social movement gives us insight into all social movements. The arguments made in court, okay, whether it's this case, whether it's the Loving versus Virginia case, those arguments and the strategies and tactics that were successful are often borrowed, adopted, and adapted by other social movements to extend rights to other groups of people as well. Okay? Just remember that. We're just looking at it through a racial lens today. And you can look at it through any lens and you can really see how they just all intertwine. There's intersectionality when we talk about discrimination. Okay? All right. Thank you for your time. Don't get into trouble. And I have to get all the way back over to here before I can turn this off. There we go. And good day.